Hi, welcome to Commercial Law Tutorials. Under this topic, Introduction to Law, we did 5 lessons: the definition and characteristics of law, the purposes of law, reasons why people obey the law, principles of just law, and the divisions of law. The lesson on the divisions of law was divided into 4 categories or parts, that is A, B, C, and D, with each part addressing a single division of law. Today we are moving on to lesson number 6. In this lesson, I will differentiate between criminal and civil law. The lesson will give the difference between criminal and civil law. Criminal cases deals with the behavior that is considered as an offense against the public, society, or state, even if the immediate victim is an individual. For example, drunken driving and murder. Civil cases, on the other hand, deals with private issues between individuals or companies, that is entities. Now, the first and foremost difference I shall highlight are the definitions. Criminal law is made up of rules formed by the state which prohibit certain acts on pain of punishment. It is the body of laws that deals with crime and the legal punishment of criminal offenses committed by a people in a state. Criminal laws, therefore, are the rules which states what shall never be done, and if someone does so, punishment is certain. The state is the one which enforces criminal laws and set punishment for each crime done through the judiciary. Perpetrators are usually taken for rehabilitation in prisons, which are also managed by the state, where they serve their given period under an authority who have been trained in that specific field. After serving their respective terms, the individuals are released back to the society. I think I have fully explained what criminal law is. Let us now move on to civil law. On the other hand, civil law concentrates on resolving disputes between individuals, organizations, in which compensation is awarded to the victim. Thus, it concerns private affairs as opposed to state affairs. In short, we can say that civil law aims to resolve disputes between individuals in a state, including organizations, with the aim to compensate the wronged. Let us look at the offenses in both criminal and civil cases. In criminal law, there can never be a crime unless a criminal or a prohibited offense have been committed. Thus, the act which is prohibited must have been committed by the offender. For example, murder. Someone must have been killed. The acts under criminal law are prohibited by the state. Then, under civil law, cases may arise even before the wrong is done. For example, one can seek an interdict that the other person or party be prevented from doing something in advance. For those who may not know, an interdict is under breach of contract, where someone who is part of a contract notices an anticipatory breach. That is, it is evident that the other party wants to breach the contract. So he, in advance, seeks for an interdict from the court, which prevents the foreseen breach of that contract. We will cover this under the topic breach of contract. There's quite a number of examples of offenses under criminal and civil law. I'll mention a few. For criminal law, there are personal crimes, which include kidnapping, rape, assault, and child abuse. Then property crimes, which include burglary, robbery, shoplifting, and vandalism. Then inchoate crimes. They include attempts, solicitation, and conspiracy. Next, statutory crimes, These include alcohol-related crimes, drug crimes, and traffic offenses. Then financial crimes. We have fraud, electronic crimes, money laundering, terrorist financing, as well as bribery and corruption. Then under civil law, we have landlord and tenant disputes, child custody, divorce proceedings, silent misrepresentation, undue influence, breach of contract. The list goes on. Let us move on. The question now arises, what kind and amount of proof is required in both criminal and civil cases in our courts? That is, the proof that the offenses we have just listed before have happened. And also, who should provide that proof? So, in criminal law, the state should prove the crime. The proof given by the state should be beyond any reasonable doubt. Take note of that statement, beyond any reasonable doubt. Then, under civil law, proof rests upon balance of probabilities. Burden of proof lies upon the plaintiff or the wronged person. Plaintiff should provide evidence that is beyond balance of probabilities. That is all on the standard of proof. We have already noticed that in this lesson, somehow, someone should have wronged another for there to be a case. There are two parties, so I will give you the names of the parties in both criminal and civil laws. In criminal law, we have the defendant versus the complainant, for which the complainant is usually the state. The state takes it upon itself to prosecute and to charge the person who would have done a criminal offense, even if the immediate victim is an individual. Then under civil law, we have the plaintiff, aggrieved, wronged versus the defendant. The next question is every case in both criminal and civil law has to do with something unlawful? The answer is no. In criminal law, the act complained about should be proved to be surely unlawful. Everything that is charged under criminal law is surely unlawful. For example, it is unlawful to steal, murder, or assault someone. While in civil law, it is different. There is no need to establish that the act done is unlawful. In child custody, someone may not be financially capable to provide financially for the upkeep of the child. Maybe he or she is disabled to work. So the cases are not always for unlawful offenses. The next difference is the intention. Do the offenders in both criminal and civil cases have the intention to commit the offense? Yes, in criminal law, the wrongdoer must have the intention to commit the offense. For example, armed robbery, someone willingly steals after planning the act. A sleepwalker or a person having some fits cannot be prosecuted under criminal law when that offense is committed during the fits or sleepwalking, because it wasn't his or her intention to commit the crime during that time. So in criminal law, it is very important that the wrongdoer must have had the intention to commit that offense. Then under civil law, a case may even arise even if the wrongdoer had no intention to prejudice or injure someone. For example, innocent misrepresentation or mistake. Now next, who initiates our cases? Who are the initiators of the cases in criminal and civil law? In criminal law, the state initiates the case. Then in civil law, the plaintiff initiates the case. In criminal law, the government initiates a criminal case usually through the attorney's office in coordination with the law enforcement agents, that is the police and the criminal investigation department. While in civil law, the wronged person is the one who approaches the civil courts to present the case. So the wronged person is the one we are saying is the plaintiff who initiates the case. Next, the pleadings. In criminal law, a docket to plead guilty or not guilty is opened. A docket is the official schedule of proceeding in lawsuits pending in the courts of law. In civil law, only the statements of claims are used by the plaintiff and the defendant. Now the summons. In criminal law, the member of the police issues it. It is the police who issues the summons. While in civil law, summons are issued by the messenger of court, who then prosecutes the offenders. In criminal law, it is either a public or a private prosecution. In a public prosecution, the decision to prosecute crime lies with the state, usually the Attorney General. In a private prosecution, the criminal proceedings are initiated by an individual private citizen or private organization, often through a private prosecutor. A private prosecutor is a private individual or entity who or which is not acting on behalf of the police or other prosecuting authority. The private prosecutor will work on the case instead of a public prosecutor who represents the state. So in public prosecution, a state attorney is involved. Then in private prosecution, a private citizen or a private entity is involved in the prosecution. In civil law, the plaintiff who brings the case to the court has the discretion to bring it to the court or waive his or her rights. Under civil law, the state do not force the plaintiff to bring his or her case to the courts. It is up to the plaintiff or the wronged person to bring the case to the courts or waive his or her rights to do so. Then the aim of both the criminal and the civil law. In criminal law, the aim is to rehabilitate the offender. The offender is punished for his conduct. Offender is usually taken to prison facilities for a stated period of time, depending on the offense done. The offender's freedom is taken away. He is monitored by prison authorities who have been trained in that special area. The aim is to rehabilitate the offender, punish, and reintroduce the offender in the society as a better person. In extreme cases though, offender is given a death penalty or even life in prison. In civil law, the aim is different. The aim is to compensate the innocent party for the wrong done. For example, in breach of contract or cases involving latent defects, or in some instances, the aim would be to declare rights and obligations. For instance, in child custody cases, the rights and obligations of parents to see, look after, and interact with their children is outlined by the courts so as to prevent any conflicts between the parents for the benefit of the children. Next, the judgment. In criminal law, upon conviction, offender may be subject to payment of a stipulated fine, community service with specified number of hours, or imprisonment, and sometimes whipping. In extreme cases, death penalty is also given. In civil law, afterwards, either or both of the following take place: compensation of the wronged person. Rights and obligations are declared to both parties, for instance, on contractual terms disputes or child custody. Lastly, who covers the costs in cases? In criminal law, costs are made by the state, while in civil law, costs are made by individuals. Lastly, let us look at the exam questions that are frequently asked. What are the differences between criminal and civil law? Distinguish between criminal and civil law. Give the differences between criminal and civil cases. What are the chief distinctions between criminal and civil law? That was all I had for you. Thank you so much for watching. If you have enjoyed this lesson, remember to subscribe, like and comment. If you subscribe, you will be notified when I post my next video.